The next speaker is Dr. Kostyantin Pylkova. He is Justice of the Supreme Court of Ukraine from Grand Chamber, and we are very grateful for Mr. Pylkova that he is, despite the hostilities and despite the war in Ukraine, he managed to come to Krakow, and he is here present with us today. And so despite the difficult connection, he managed to come. And Dr. Kostyantin Pylkova also, he is an associate professor at the Department of Civil, Commercial and International Private Law of the Kyiv National University of Trade and Economics in 2016 till 2022. Occasionally, he gives lectures on the topics of evidence and sanctions as a guest lecturer of the National School of Judges of Ukraine. Prior to becoming Supreme Court Justice, Pylkova had been practicing law as an attorney and arbitrator at several national and international arbitration institutions. And as I mentioned, Dr. Pylkova is a justice of the Supreme Court in the Cassation Commercial Court since 2017. In 2020, he was elected to the Grand Chamber, where the most important cases of commercial, civil, criminal, and administrative jurisdiction are decided upon in order to develop unified application of case law. So, dear Justice will present the topic from the rule by law to the rule of law, the evolution of application of basic legal principles in the Supreme Court jurisprudence. So, dear Justice, the floor is yours.
Thank you.
You may take a seat here. I think it will be more convenient.
Thank you very much. I'm very pleased to be here in this very room upon the invitation of the Jagiellonian University, and I'm very pleased to be talking to you, my dear colleagues who are present in this very room, and the broad audience that is connected to this seminar via Zoom. After the very interesting presentation by Professor Shabas, we are getting back to the issues related to Ukraine. And my presentation, what I'm going to talk about to you today, is more optimistic part if compared to what Professor Stanislav Shevchuk covered in his very interesting presentation. I will share several slides of presentation so that you can see some figures, some bullet points, and not only my face during those 20 minutes of my presentation. During the darkest hours of the early spring of 2022, the Ukrainian government reaffirmed the aspiration of Ukrainian people to join the European community of the European states, and reaffirmed the pledge of allegiance of Ukrainian people to the European values. We remain on this path towards the European future of Ukraine, and if there is going to be a discussion after my presentation concerning the meaning of this direct application of constitutional principles, general principles of law, and area-specific principles, I move for the motion that this is a good thing for Ukraine to move into that direction. There was not always the same situation in the judiciary. In 2012, in one of the most comprehensive and probably the only comprehensive study on the application of general principles of law by the Ukrainian judiciary, Dr. Uvarova outlined several tendencies that were dominant in the judiciary. The most important of them is that common courts, especially courts of first instance, refer to the principles of law rather formally. They were used as a kind of declaration or even decoration for the text of the domestic judgments, without relying on those principles as a separate and sufficient ground for deciding upon the case. I believe that there were several factors or several waves that led to change of that situation. Before that, by the way, I heard during one-to-one, during the professional discussion that I had in this room before we started this seminar, I understood that the situation in Poland was quite similar. So we are following the experience of Poland, and probably I might expect for the insights, for the comments, for friendly remarks and criticism from the professional community that we have here. So in Ukrainian legislation, in several procedural codes, and even in the Civil Code of Ukraine, we have probably the only one provision as to how the general principles are to be applied. And it's this provision that you can see on your screens. So the general principles of law have to be applied as an instrument of last resort, when there is no clear specific provision in the written law governing the relations that are in dispute. So is the gap-filling function is a sole practical feature of general principles of law. I move in favor of the motion that at least it is no more. And as I mentioned before, there were several factors that gradually led to the situation that changed, and I hope changed in a positive way. In 2006, after the Ukrainian parliament adopted a special law aimed at enforcing the judgments of the European Court of Human Rights, with a specific provision of that law, the judgments of the Strasbourg court formally became the source of law. That was very important for the Ukrainian legal system, which still remained on the pure legalistic and pure positivistic principles. So in that way, the ground was prepared for the conventional principles as they are viewed by the European Court of Human Rights to enter the realm of the sources of law that are to be actively applied by the Ukrainian courts. Next wave, or next set of factors that led to change of the situation in Ukrainian judiciary took place, I believe, in 2017, when significant amendments were introduced to procedural codes. Actually, the procedural codes were redrafted and issued new versions. And those procedural codes now contain the provisions according to which common courts have the power to disregard unconstitutional laws in a particular case. Before that, if a common court had doubts about the constitutionality of a particular provision of a particular law, it had to refer that matter of law to the Supreme Court, which in its turn had to, or rather had the power to further address that problematic issue to the Constitutional Court of Ukraine. And if the respective provision is recognized by the Constitutional Court of Ukraine as unconstitutional, it never applies, and certainly that judgment has erga omnes effect. After 2017, the situation changed dramatically. The common courts, even the court of first instance, now has the power to disregard the law that he believes is unconstitutional, and after that refer that issue of constitutionality to the Supreme Court, which in its turn has the power to address it to the Constitutional Court, so that the opinion in a particular case, which has inter partem effect, may have erga omnes effect, so for the whole society, not just for the particular case. Next part of the significant changes that took place in 2017 is the, as I call it, influx of scholars and representatives of other branches of law practitioners into judiciary. There was a reloading process of reloading of the Supreme Court, and new blood flowed into the judiciary. Many representatives, especially that I value, many representatives of the scholars became justices of the Supreme Court and brought new knowledge of new doctrines which are not native for the Ukrainian case law, for the Ukrainian legal system in general. And with that knowledge of those doctrines in their brains, they just cannot physically contain that knowledge to themselves, and that bursted into a new wave of ideas on how to apply new doctrines that are basically founded on the principles that are actually embedded into Ukrainian laws. I will come to that later and illustrate that with an example. And the third and probably last important part of that wave that led to the change in application of principles is the creation of the new structure of the Supreme Court. Now it contains of 5 main structural entities. 4 of them are courts of cassation that according to the specific jurisdiction. There is a criminal court of cassation, administrative, civil, and commercial court of cassations. They are governed, their procedure is governed by their separate code of procedures. But there is also Grand Chamber, which consists of the representatives from each court of cassation, and that deals with the most problematic issues which might be referred by each of the courts of cassation to the Grand Chamber. And I believe that creation of that mechanism of Grand Chamber led to the transformation of the understanding and application of general principles. Since before that, every specialization, every jurisdiction was like in its own environment. And it was easy to say that some provisions, for example, of a specific procedural code that have mirroring or similar provisions in other codes, that they might be applied somehow differently, and no other jurisdiction shall get into this discussion trying to discuss that those provisions actually should be applied and interpreted in a similar way. the Grand Chamber took different approach, completely different approach. It was not hiding behind the facade of formal difference between courts. In many cases, the Grand Chamber said that although procedural codes are formally separate laws, and there might be difference between them, but if there is a similar approach, for example, between civil procedure and commercial procedure, they both are adversary. They promote the party autonomy. Basically, they share the same approach. That means that if some procedural issues are decided differently in different jurisdictions, there is something wrong with that, and that difference might be reconciliated on the basis of general principles. That led to the application of general principles of law, mainly by the Grand Chamber. So as you may see in this slide, these waves, these at least 3 waves of changes, gradually brought to the Ukrainian case law the application of the conventional principles as they are interpreted by the European Court of Human Rights, constitutional principles, still on very rare occasions, but we are talking about the tendency, not the results in large numbers. So constitutional principles and general and area specific principles. Now let me illustrate what I'm talking about when I'm mentioning the application of principle. Let us take an example of the application of doctrine of prohibition of inconsistent behavior, or venire contra factum proprium, as it is in Latin, and as that Latin maxim is often used in Ukrainian judgments since 2018. You will not, I believe you will not find in the Unified State Registry of the judgments any judgment prior to 2018 where that doctrine is mentioned. And since that year, as you can see from this chart, there is gradual increase in mentioning of that doctrine. Not those figures do not mean that it's the number of the judgments that are based on that doctrine, but there is a great part of ever increasing number. In 2022, due to the full-scale invasion, I believe that tendency slightly changed, but I believe that still you may see what the point that I'm trying to illustrate here. So this doctrine, which is not native for the Ukrainian legal system, which was never, before 2018, applied by Ukrainian courts, revived the principle of good faith and fair dealing. That very principle, principle of good faith, was in Ukrainian civil court just from the beginning, as well as the principle of, for example, reasonability in civil relationships. But since it was too broad to be applied, it was rarely applied as a separate and sufficient ground for deciding upon the case. When the mechanisms were created, when the ground was prepared by the application of the principles of the European Convention on Human Rights, and when the people, primarily the scholars, entered the realm of judiciary and brought the knowledge of those doctrines. As I told before, the situation changed, and the sleeping principle of good faith obtained an application through the very specific doctrine of prohibition of inconsistent behavior in civil cases. There are many other examples where the specific doctrine, which was like a foreign for Ukrainian judges, but actually was founded on the same principles that are embedded into Ukrainian legislation, is now applicable, directly applicable, even to the extent that the application of specific doctrines or principles may displace the specific provisions of the written law, the so-called contra legem application, especially in those cases where something needs to be done by the court ex officio. For example, in land law disputes, we have a rather outdated provision of the written law regarding the remedy that is to be applied in case one of the parties of the land lease agreement, let's say, procrastinates with the matter of prolongation of the lease, of that lease agreement, when the other party has expectations, legitimate expectations that that lease agreement might be prolonged. And the law provides with the remedy that formally that is constructed in the law as the challenging the unlawful delay with the signing of the additional agreement. However, in Ukrainian case law, it is almost universally by the practitioners of law recognized that those decisions on obliging a person or a state authority to sign something or to decide upon something are difficult, if not impossible, to enforce, especially if the respondent is a collective entity. I mean, like a municipal authority or a state, a local council that consists of many peoples, who should be brought to the responsibility in case of non-compliance with the final decision. The whole body, the majority, the ruling majority, the whip of the majority, who did not perform the tasks of assembling the council, that led to the opinion that those decisions are almost impossible to enforce. And the Ukrainian case law invented a remedy only based on the principle of the effectiveness of the justice, which was taken from the European Convention, which obliges the states to provide the effective remedy. However, the convention obliged the states to provide effective remedy against the violation of the conventional rights. But Ukrainian judiciary interpreted that provision of the convention broadly, that the whole administration of justice has to result in an enforceable decision, and it's ex officio duty of the court, of the judge, to provide with the effective remedy. And thus, the case law and the application of the principle of the effectiveness of the justice, like overruled, replaced the clear provision of the land law. Probably in 2022, we had a fourth wave of these changes in application of general principles. The Grand Chamber had an energy sector case, which was decided in a way that the Supreme Court promoted the direct application of some principles of the European Union law, in spite of the fact that it is the legislator who is expected to have on its shoulders the main burden of the approximation of the Ukrainian domestic law with the European Union law. But the Ukrainian judiciary, having the understanding that our process of joining the European Union requires preparation, requires readiness, not just legislator from the beginning, and then after there are disputes, there will be the turn of the Ukrainian judiciary. Ukrainian judiciary also took part in this process of preparation, and the Ukrainian legal system becoming ready for the joining to the European Union, and issued an opinion according to which in specific sectors the Ukrainian law, the principles of the European Union law have to be applied in the same way as the principles that are embedded in the Strasbourg court judgments. So I believe that this is a fourth wave that led to application of the European Union principles of law. Now to the interesting part, after which I expect the lively debate in this audience and among participants that are participating in this seminar via Zoom. I found a survey conducted last year, and according to the results of this survey, which was related to the direct application of the general principles of law, the majority of the European countries, at least those that participated in that survey and provided country reports, applied the general principles only in case there are clear gaps in the written law. And Ukraine, which, as I moved in favor of the motion that the application of principles is a good thing, is becoming a member of a rather tiny club, rather tiny community of countries that apply the principles directly, among them France, Netherlands, Greece, Bulgaria, Hungary, Latvia, and Luxembourg. So I kindly ask the members of the audience of today's seminar to find your country in that list and probably comment, reflect on that, and share your views on whether the situation is really as it was presented in this survey. On a separate note, and rather to clarify my views on the application of principles, I would refer to the book of Tokyo University professor Dr. Kono, Efficiency in Private International Law, where he distinguished between rule and standards, the main approach of the legislator to regulate the social relationships with clear and specific rules for every situation, or rather stick with the standard approach where the standards are the main instrument. For example, the rule might be very specific, with establishing specific terms, deadlines for some deeds and transactions, whereas standards refer to, for example, standard of reasonability, standard of fairness. It relies on flexibility in application of the law. It relies on the common understanding of common concepts. That understanding has to be common among all members of the society and the judiciary. So I believe, and by the way, the reasonability, the fair deal are recognized in Ukrainian, for example, civil law as principles of the civil law and principles of the civil relationships. Is it the same with your jurisdictions? Because if it is so, then I believe we have to distinguish those standards from the realm of other principles, because there is a significant difference between the principle of reasonability and, for example, principle of continuation of public service, which is supra-legislative, has supra-legislative importance in France, for example. There is no room for assessment. There is no line where we can assess the continuation of public service, whereas there is one in case of reasonability. That behavior is more reasonable, less reasonable. Where is it on the spectrum? So this is where I'm going to wrap up my presentation, where I'm going to end with my speech. I will be happy if you have any insights, any criticism or comments, any thoughts you might share as to whether I'm too optimistic in my assessment of the progress that Ukrainian judiciary is making in its movement from purely logistic, from purely positivistic approaches in application of the law, where some not unpredictable, but paradoxical outcome, and not always fair, might take place, towards the application of standards, new doctrines, and principles in general that might lead to more flexibility, but less legal certainty, for which the national judiciary might be criticized. Because one of the main tasks, one of the main obligations that the Ukrainian Supreme Court was entrusted with was to secure legal certainty, the predictability of the case law. And if we are moving simultaneously in both those directions, if we are trying to secure the legal certainty, the absolute predictability of court judgments, it might be hard to apply the approach of using standards as the main legal reason, as the main legal ground for deciding upon the cases. And probably it is for me and for my fellow colleagues in the judiciary, as well as for legal scholars in Ukraine, to explain that it is not quite possible to move simultaneously in those two directions. Either we choose the standards, more flexibility, and predictably more legal certainty, or we choose the rule approach where we have that legal certainty, but the result might be dura lex sed lex, which was mentioned by Christina Trichlip the day I came to Kraków, and which might be used as a facade for justifying the decisions that are not quite in compliance with the general understanding of what is reasonable, what is fair. By this, I'm going to stop my monologue. Thank you all for your attention and express my gratitude to the host of this seminar and express my sincere interest in the debate, in your questions, reflections, and comments upon